Hello, welcome. Thank you all for joining us. My name is Pete Calabrese. I'm CEO of Can-Am Investor Services. We are the FINRA registered broker-dealer affiliate of Can-Am Enterprises. And as we've had the pleasure of being joined with before, but once again, have with us Mr. Joey Barnett, partner at WR Immigration, as well as Mr. Charlie Oppenheim, as if he needed any sort of introduction as it is, the Director of Visa Consulting at WR Immigration. Gentlemen, thank you as always for joining us.
It's a pleasure.
Thank you for having us, Pete. We are always happy to speak with Can-Am and other people about EB-5 and other fun U.S. immigration topics. And Charlie's the Notre Dame of the visa backlogs and things like that. So it's great to be able to be on a panel with him and share his insights.
Well, likewise. And, obviously we've gotten to speak with you guys and share your insights on the Visa Bulletin, which is always fantastic, which is why we scheduled this to make sure that we could talk about that all important first Visa Bulletin of the new fiscal year. But as is always the case within the EB-5 world, other plans came into place and definitely took a little bit more of the information. So, uh, we're even luckier to have you guys here today to talk about what was announced, what is now last week as we were recording this on, is the gold card. So, this is something that had been fully conceptual for a long period of time. There was discussions about it. There was some ideas of what it would look like, about what it would be in terms of cost, where these things were coming from. And with the limited amount of information, it was really difficult to know much about anything than tangential guessing about what it was. Well, that changed. And as much as we will, and we are going to talk about the Visa Bulletin as well as the what this means for EB-5, as always, I think it's a valid time to talk about what we know from a gold card standpoint, what has been anticipated in terms of, say, where the gold card allocations could be coming from, and to maybe give people who are listening out there who don't know as much about maybe some of these other visas, especially not as much as Charlie, to give a little bit of insight into how these different visas are handled, namely the EB-1, EB-2, as well as how those ones interact in the overall visa allocation landscape. So, gentlemen, got a little extra on our plate here, but I think this is a good time to speak about it. And thank you again for going into this. I want to make sure that everyone is
Absolutely.
aware.
And I think just like what happened in February when the Secretary of Commerce announced the gold card in the Oval Office, we had a huge blow up in interest in EB-5. We're seeing it happen again now. And I think whenever there are things that cause a little uncertainty or cause people to panic because we don't know what the future is going to be like, people want to take action. And so I'm glad we're talking about this. And again, thank you for having us come on, Pete.
No, of course. And as you'll see, we have a lot to cover here today, and many people have come in here have probably heard about us. Please feel free to give a little bit of information about WR Immigration, Can-Am. You can visit our website to hear a little bit more about us. Obviously, we're one of the more successful regional centers in the history of the program, as well as one of the largest in terms, I believe, the largest in terms of repayment of capital to investors. So, without further ado, Joey, Charlie, maybe just walk us through a little bit of what we now know from a gold card standpoint, and what this potentially now means for people as they're trying to make a good, practical immigration decision moving forward.
Yep. So the gold card executive order was signed last week, Friday, the 19th of September. And it has directed the Secretary of State, the Secretary of Commerce, and the Secretary of Department of Homeland Security to create this new visa program and to implement regulations and create applications and put together the administrative framework in order to adjudicate this new visa program. And the visa program is very different than what existing immigration law requires. And it's very different from EB-5 because, and we're going to get more into that, but here, this is a donation to the government to pay down debt. There is no return of the investment. And so the investment levels vary. depending on who is making the donation. And if it's an individual, that investment amount is 1 million. If it is a company that is making the donation on behalf of an employee, that amount is 2 million. And there's also something that was mentioned called this platinum card, which wasn't in the executive order, but was mentioned on Twitter, which I guess is potentially how laws are created in 2025. And he is the Secretary of Commerce, Lutnick, had said that they may need to go through congressional approval for that. But the big thing here is it gets you a pathway to a green card based on your donation to the federal government. And what this executive order indicated was that by making that donation, it counts towards certain EB1 and EB2 criteria, whether it is a national interest or showing that you have exceptional business ability. And so it sort of rewrites the law and the eligibility requirements for EB1 and for EB2, or at least expands the eligibility requirements for EB1, EB2. That's how I read it. Now they're very clear here that just because you're eligible by making a gift, that does not mean that you are for sure going to get a green card. There are other items and grounds of inadmissibility, national security checks, prior immigration violations, concerns related to public safety, all that type of stuff that they are going to go through no matter what, just like they do for EB5 applicants. And that's part of this process as well. But the big thing that the EO did was push these administrative agencies in the executive branch to create this new visa program. There's a number of things that we don't know about it, but I think the biggest question mark that we have, and I'm glad that we have Charlie to talk about, is that the executive order specifically references EB1 and EB2. And by that very fact, it limits, I think, the number of people who would be desiring to do this type of program. And so maybe, Charlie, you can key us in on that as to why EB1 and EB2 categories for this gold card program could hamper its actual overall impact.
Yeah, the interesting thing is if these numbers are going to be charged against the EB1 and EB2 categories, the question is, are the people that are applying and establishing a priority date, are they going to go to the back of any respective lines? For example, if an Indian or a Chinese applicant applies, are they going to have to wait until their priority date becomes available in either the EB1 or EB2 category? If so, there's really at this point, with the final action dates applied to China and India, there's really no benefit to them. And again, one of the things that was mentioned is potentially charging these numbers against the diversity visa lottery limit. That would be the ideal thing, is to pull numbers from DV. That way it would not disadvantage those applicants who are already in line in the EB1 or EB2 categories.
So that's something that Secretary Lutnick tweeted about. That was not in the executive order, but it's possible that in these interim 90 days in which the secretaries are supposed to be creating the regulations and how they're going to execute this, that comes up as part of their decision-making process. Now, what they're supposed to do a lot of times is create these regulations. There's public notice and comment period. Maybe they change the regulations after those comments. It remains to be seen what exactly is going to happen prior to them actually being able to accept the donation or the gift. The other thing that I've been thinking about is the way that these EB1 and 2 applications are processed is you have to show that you're qualified and then you make the application. So are they going to require people to make the donation and then apply? What happens if your I-140 is denied after making the donation? Is there ability to get the money back at that point, or are you all in? There's also this national security vetting. That comes after the I-140 could be approved potentially. Well, if that doesn't go according to plan, are you going to get your money back? So a lot of open questions that we don't have the answers to, that supposedly we will be getting in the coming months as they put this together. But there's also a lot, this uncertainty is, I think, creating, I guess, a little bit of waves and anxiety because we just don't know what to expect. We don't know what the process is going to be. We know that it is a gift to the Treasury and that you are not getting the money back. But beyond that, we don't understand the real process. You're supposed to do it online through trumpcard.gov. I have signed up. I have put in my name. Actually, it's my cousin's name as an applicant. It's Jorge Barnetto. He is ready to immigrate. And he is ready. He is signed up, and he will be getting all of the information as required when it becomes available. He hasn't gotten anything yet. So they haven't accepted applications. I don't know what the Secretary, Howard Lutnick, is talking about when he mentioned that there's already a line for the Platinum card and that there's thousands of people in line. There's no application process. How could there be a line? And so we have to there's, I think, some political messaging that's associated with this. And we just have to be aware of, what is real and what is not real. And I guess I'll pause there and see, Pete, what do you got to say? Yeah.
Yeah, I couldn't agree more. I mean, I think with all of this, again, we're here to try to help people to make good decisions in terms of their investment, their immigration by investment. And even with this, now that we have a little bit more information, because we think about the early conversations about this gold card, there was an even higher concept, and it was higher investment amount, $5 million. And there was all these tax benefits that were going to come with it. And there was expedited processing and all these sorts of things. And then obviously, as you go through, this is clearly a something that the administration is very interested in implementing. And, as we've all noticed on our side of the industry, is that the conversation of this has gone rather quiet for a pretty extended period of time. So clearly they were gathering information, and they've now come to something that is now a little bit more focused. And there is some reality to it. And practically speaking, people could start to consider this as an option, but there are very, very key differences between this and what we talk about all the time, and what is a prime focus of our business, which is EB5. And mainly, it's you are going to be making a capital contribution as opposed to making an at-risk investment where you're able to get your funds back. And when structured right, good regional centers like Can-Am, they're able to achieve those immigration benefits consistently and predictably. What we're looking at now from the gold card is on its face something that is a little bit more of a rapid time frame. They talk about priority processing, which is potentially available for these. But, Joey, as you alluded to multiple times, this is there's still to be questioned what point this actual capital contribution is made, because what's very clear from, you can read that, is that this is a non-refundable gift. So, if, you're subsequently, lose your benefits, or, look, any of the different complications that could come along with the gold card, such as, legal, there could be litigation that comes as a result of this. Who knows what the result of that would be? Who knows what that would mean for your ultimate immigration? But we're talking about a non-refundable gift that you're looking at. If this is something that is able to move forward as an executive order, would a subsequent executive order potentially be able to impact that as well? You would have to assume yes. So what effect could that have, again, on your non-refundable gift? So, I mean, these are factors that you have to put into place, and clearly you have to be of the financial security to be able to make such a large investment with no expectation of return. But these are the factors that people need to take into account with, again, the limited information that we have before we get probably near the end of this 90-day implementation process that will be potentially bringing this online. But again, as we talk about helping people to make good practical decisions, what we always revert back to is that EB5 clearly is our main line of business. It is one of your huge lines of business that you guys are very successful in. It is a program that is in place, that has legislation in place, that the parameters of it are very well known. And that predictability is a good thing when making these sorts of decisions. And so having that in place is certainly still a huge, huge benefit. So obviously we put this up here, and for any of those people who are listening here that could maybe use a refresher on what the EB5 program is, and potentially, Joey, if you want to walk through a little bit of that.
Yeah, the EB5 Investor Program has been, the Regional Center Program has been in existence since 1992. It's been extended dozens of times by U.S. Congress. It is a bipartisan immigration success story as far as I'm concerned. It's created thousands, hundreds of thousands of jobs and created a lot of billions of dollars in investment into the United States. It's a job creation program that provides the immigration benefit if the jobs are created, which is why working with regional centers like Can-Am that have the experience putting deals together, finding projects where the construction is going to occur, where the job creation is going to occur so that people can achieve their immigration benefits is so key. And it is set to expire currently in 2027. It is a short-term program that Congress has always extended. And right now there's efforts to extend the grandfathering protection. It says projection. I realized I have a typo. It should say protection. Currently for those who are filing their cases before September 30th of 2026, we think that's going to be extended out actually. And that they should protect anybody who files as long as the law is in effect. Sorry, I did want to just make one mention, sorry, before we move on from Gold Card, because I thought this was a good point, is that they don't mention whether derivative beneficiaries are included. And that's something that in EB5 we've always talked about. The legislation talks about, green cards to investors, 10,000 investors. Does that include derivatives or not? USCIS has always determined it does include the derivatives. That's how it is for EB1 and 2 and 3 as well. It's the principal applicant, it's the spouse, and any unmarried children under 21. We don't know if it's going to be like that for the Gold Card. And so it's possible that we may need multiple donations in order to cover the entire family. Again, something that is an unknown and will impact the number use as well.
That's a great point. Yeah, and hugely important. Because, especially again, when we talk about the things that we don't know, you and I had spoken about this earlier, when you talk about the implementation of a corporate Gold Card, it's difficult to understand, practically speaking, how there could be that sort of transition between corporation, your large tech firms who are sponsoring a highly valued employee to be able to have this. Well, how can they transfer that between not just the employee, but the employee and their families if derivatives are a part of that petition as well? So it's a great point. Thank you.
Yeah. Charlie, have you ever seen anything like that in other immigration programs? I mean, Gold Card to me, it's very innovative. It's totally out of right field, but that to me is something that I could see some pushback on because it really doesn't, sort of key into the existing immigration law.
Yeah, this is something I've never seen and don't remember ever before my taking over as chief in 98. I never remember any time when there was an executive order establishing a brand new visa category. So this is brand new, uncharted territory, and how Congress will ultimately feel about that is anybody's guess.
Right.
Yeah, absolutely.
Yeah, I feel the same way.
Well,
Well, let's talk about, I guess, what we do know, right? Because that's why we're here, and that's why Charlie's expertise is here. And we've seen in this unreserved category for EB5, which is for people who filed before 2022, we've seen those final action dates ping pong and bounce back over this past fiscal year, which ends next week. And this chart here that you're looking at shows kind of how it retrogressed in the middle of the fiscal year, and then how the Department of State moved the dates forward. But they haven't brought them all the way back, right? And so, Charlie, what do you see here? I mean, and what do you expect to see, I guess, in the coming months
Yeah, I
for
think
these
this is an
unreserved
interesting
categories?
chart. Uh, with the retrogressions which occurred for April, that indicated that the State Department's original estimates of number use were incorrect. They realized they had to retrogress the dates to limit future number use under the annual limits and to allow the rest of the world to remain current. Then suddenly in August, they did a recovery from those original retrogressions, advancing the dates, which tells me again that they realized that their April estimates were also incorrect, and that they suddenly needed to move the dates forward to maximize number use under the fiscal 2025 annual limits. So that that's kind of a worrisome situation to me to have such back ping pong effect so quickly. I think that the reason, for example, in China, that they did not have a full recovery, we only lost out by a small amount, is that they realized that they overestimated the availability of China numbers for fiscal 2025. They did not want to make that same mistake again in 2026. Therefore, they're being very cautious in their forward movement and recovery of the China unreserved final action date. I would expect the China date to probably hold for several months. There's really no need for them to aggressively move it forward and risk having to have recover or some type of retrogression potentially later in the year. There's so much demand out there. They can move the China date at any point and ensure that they can maximize number use. For India, I would expect the India date to continue to advance toward potentially a full recovery, because on that's a flip side. There should not be that much pending demand for India. Unfortunately, the State Department has not been forthcoming in releasing any waiting list type of data to let us see what they have still pending. But based on the data that they did release in May of 2024, I think that by this point, much of the India demand should have been taken care of. And therefore, I would expect the India date to continue advancing toward a full recovery.
And the Department of State said earlier in the month that all of the unreserved visa numbers for fiscal year 2025 were used. So it's not like we're seeing wasted visa numbers here, like we may have potentially seen in past years or something like that to a minimal extent in the unreserved category. Like they're doing their job and using up all of the visas. So to some extent, maybe their estimates were over or too big or too under, but ultimately they ended up using them all.
Yeah, and that's to my point. There is so much pending demand for China mainland born, and that they can move the dates later in the year without having to be concerned with not being able to maximize number use. And I always felt that it was better to have smaller incremental dates until I was absolutely sure about the availability of extra numbers before I made any drastic moves in the dates. I also always felt people were more comfortable if they saw the date advancing steadily rather than having a big jump and then it hold for an extended period of time.
That makes sense to me too. It's easier to plan that way, and people get less concerned when they see retrogression, and then they get bogged down and feel like they're not going to actually be able to move forward for this because they have to keep waiting. That makes sense to me.
Yeah, I mean, predictability is a key aspect of this as you're trying to make, real good plans for your future. And yeah, the idea that the date that you're looking at could potentially move backwards on you was pretty jarring when it happened. But it's good to see smaller incremental moves forward here, and hopefully that's the case that people can expect as they go forward. Uh, Maybe now it might make sense to shift on to the broader the visa bulletin to talk, and obviously EB5 is a big part of our conversation. But thank you for putting this together, both Charlie and Joey, to illustrate now as we start to bring the idea of these EB1, EB2 visas into the mix as something to consider for people to have an idea of what that section of the bulletin looks like, as well as a further discussion of EB5.
Absolutely. So this is the Chart A final action date chart for the Visa Bulletin for this upcoming month, October 2025. And there was a number of forward movement in the final action dates, including the India unreserved. And Charlie, why do we see that?
For October, they had their brand new supply of numbers under the fiscal 2026 annual limit. So they were able to advance the dates. I feel that in many of the employment categories, they advanced them at an overly aggressive rate, which I think when they do so, they increase the risk for requiring corrective action later in the year. It also needs to be remembered that most of the employment categories, 1, 2, and 3, were unavailable for August, part of August and or September. That means that during October, both USCIS and the State Department are basically having to play catch up, processing cases that would have been processed during the end of fiscal 2025. Therefore, that would contribute to put, in my thinking, the State Department having limited, if any, forward movement into the dates in the next month, a couple months. Again, the pattern which I predicted 2 fiscal years ago is the State Department seems to be advancing the dates very rapidly on a quarterly basis in October, January, April, and then again in correct whatever they need to do at the end of the summer. So again, I would not expect to see this type of dramatic movement, in some cases up to 3 months advance of dates.
Got it. And the big thing that I want people to understand is this doesn't say how long you're going to be waiting for a visa if you're filing today. That is not what a visa bulletin does. That is not the purpose of a visa bulletin. That is what some people use, I guess, to help estimate when a visa will become available. But it does not show you that is when how long you're going to be waiting. And the big thing I want people to look at is for the EB2 and EB3 categories, there are final action dates for everybody. So even if you had an employer, even if you were born in England and you had an employer sponsor you and go through the perm and get the I-140 approved, well, that employee still wouldn't be able to get a green card because he filed after December 1st, 2023. And the same would hold true for anybody who applied for a gold card and filed an I-140 on December 30th, 2025. Well, there's not a visa available in the EB2 category. There is for EB1, but not for Chinese and not for Indians. And so this is what we were referring to earlier in the call about how it limits who actually is going to be able to take advantage of the gold card. Whereas if you look at the set aside or reserved visa categories at the bottom few rows, you see that those are current. That means that there is a visa immediately available for someone who is in the United States and can file an adjustment of status based on their EB5 application today. That allows them to file for an EAD, allows them to file for an advanced parole, and gives them a plan B in the event something were to happen with their non-immigrant visa status and they aren't able to maintain it. Well, they have a pending adjustment of status. they're in a period of authorized stay, they're not accruing unlawful presence, and they're able to remain in the United States. That benefit is available right now for EB-5 visa applicants, and why we are seeing such a huge increase. That concurrent adjustment is not available based on a gold card investment unless you are doing EB1 and not born in China and India. So again, I just wanted to make that distinction here because we were talking about gold card earlier.
Which is a huge one, because it's part of what we talk about with EB-5 constantly, right? And we'll touch upon this a little bit more, but there has to be the expectation that there is going to be, if not already, if you're in one of the unreserved categories, if you're in the reserved categories, there is eventually going to be a date of final action. But the opportunity that presents itself with that concurrent filing is a huge one. And it is something, again, we'll touch on a little bit in a bit, but that is not necessarily something that would be available for EB1 or EB2 if you're Chinese or Indian. So this is where we get to put on our thinking caps here for a second, and obviously enjoy the scenery that you guys were able to provide. It's kind of like the Zen moment on the Sunday Ticket. But Charlie, what will happen with unreserved China and final action dates in the coming months? If you had to put on your Notre Dame cap, as Joey referred to it before.
Yeah, as I mentioned earlier, I would expect for China unreserved that the October date will be held for a number of months before it begins to advance. The one issue here I have with saying that is if Guangzhou were to notify the State Department that they had any staffing issues which would preclude them from processing cases later in the year, then that could require the State Department to go ahead and advance the China unreserved date now to process more cases when the staffing pattern allows so. So that's kind of a wild card. In terms of the India final action dates for unreserved, I think that the India, as I mentioned earlier, that the India unreserved final action date will progress in a steady manner, and I would expect it hopefully within the first 6 months of the year to have a full recovery to the latest fiscal 2025 final action date. And the one reason for it's important, applicants are very interested in the recovery of dates, but it's also good for the State Department and USCIS. Because the State Department gets inquiries from congressional staff, attorneys, whatever, saying, where is my client's case or my constituent's case? So somebody might have been right about to have their case finalized when there was a retrogression, and suddenly they're in limbo. Well, the State Department USCIS has to have staff answering all these inquiries saying, when's Charlie's case going to move forward? So it's to their advantage to have a recovery so they can stop answering those type of questions and have those staff members address other more pressing issues. So again, in this regard, it's as much in the government's interest to have a recovery as it is in the applicants.
So that's what we should expect to see in the coming months. And, if anything is, Charlie's kind of predicted what was going to happen in this month's visa bulletin, so I wouldn't be surprised to see him be correct again in the future. All right, so this slide here is about this new fiscal year. This is an estimation. We don't know the annual limit for employment-based preference for fiscal year 2026. Charlie, do you have any idea when we normally would find out that number?
The State Department will basically have the information to make a preliminary call by no later than the end of October. They'll have enough information, like I said, to give a preliminary estimate. They did so in 2024. They did not give an early estimate for fiscal 2025. But for this chart, I assumed that the limit will be approximately 150,000. and that's based on what happened for fiscal 2025. And in a worst case scenario, this assumes that there'll be approximately 10,000 unused family numbers that were not used during fiscal 2025. Those numbers are automatically added to the fiscal 2026 minimum of 140 for employment. But even if my estimate were a little high, it only amounts to maybe 2,000 numbers in the employment on a worldwide basis and about 200 numbers on a per country level. So it's not statistically significant, and this gives us an idea where we may be able to go for 26.
And these numbers don't include the carryover numbers in the EB5 category, where the reserved unused get carried over for one more year, and then if unused again, get carried over to the unreserved category. And that's what this next slide shows is with the carryover, what those limits would be on a worldwide limit and on a per country limit. So that's what we have here. And if there are any otherwise unused numbers in that, a country can get more than the 7%, and that's based on priority date. And that's why we have seen China historically get the large majority of EB5 visas in the past, and likely will continue to do so based on the current demand. This next slide, I have a lot of fun with this thing. I call it my visa waterfall. I don't know why I call it that. It's a waterfall because the unused visas fall down to the next year. And so what we have here, thank you. So what we have here is what's going to happen in this fiscal year 2026, which is the top row. And like I just mentioned, any unused visas that were initially allocated in the reserve category in 2025, there wasn't enough use in fiscal year 2025. So all of those are going to carry over to the reserve category in fiscal year 2026, which means that we are going to be having close to 8,000 or so, I believe that's close to 7,000 or so reserved visa numbers for fiscal year 2026. We also have, I think, another 11,000 or so in the unreserved category. So lots and lots of visa numbers that are available. Hopefully, again, we can see that these all get used. Charlie, did you have anything you wanted to mention on this slide?
No, I think this is an excellent slide showing how the carryover provision, it's an excellent provision. It's not available in any other employment category. So this has provided tremendous benefit, not only to the reserved categories, but allowed a significant amount of additional demand to be processed in the unreserved categories. So this carryover is benefiting everybody.
And this next slide breaks it down a little bit more. We have the reserved carryover from last year, or I guess the current year, and then the reserve rural high unemployment for this year. And that shows how many visa numbers are available in each one of those visa categories. And so again, lots and lots of supply of visa numbers available that need to be used by folks with approved I-526E petitions. This next slide that we have, I think, Charlie, I think this is a good conceptualization on how you would sort of estimate how many numbers could be used for China after the per country cap is met. Can you maybe go through that and explain what that means based on this fiscal year 2026 unreserved limit?
Sure. Basically, what I did is I started out, just for make the math easy, an 11,500 estimated unreserved annual limit. For the rest of world pending demand, what I did is I looked at the latest and only available data published by the State Department, or provided, which was provided in for a IIUSA conference in May of 2024. I used that data to determine how many of the rest of world cases are still pending. I estimated 3,500 numbers would be required. I also estimated the fiscal 2026 annual limits for unreserved for both China and India. We know that all their per country limit will be used. So I subtracted from the overall limit the 11,500, subtracted the 3,500 assumed rest of world demand, plus the 1610 numbers used by India and China. And that lets us have 6,390 numbers under the annual limit, which are unused. And otherwise unused numbers are then provided strictly in priority date order to applicants from any country which has already reached its per country limit. Therefore, all 6,390 numbers would go to China applicants. And this would be a extremely good benefit for reducing the China wait time and pending demand in the unreserved categories.
Thank you. I think that's so helpful. I mean, that really shows that of the 11,500 unreserved, over 7,000 of those numbers are going to be going to Chinese in the existing backlog. That's way more than their 7% allocation. And it's something I think people need to understand. But if you're still with us, and I'm sure you are, because you're listening to my voice, the real question becomes, well, is there going to be final action dates in the set aside or reserved categories? Part of that relates to this dual approval category that we get in the I-526 approval notices. And if you look at some point, there could be a final action date, and there likely will be a final action date in the rural and high unemployment categories when, just wait 2 minutes and we'll tell you when. But when that happens, people from the rest of the world will be backlogged. And so they would have the opportunity to use numbers from the unreserved visa category because their I-526 approval notice has dual categories. And as more and more people use those unreserved numbers, that actually is going to reduce the numbers that are available to Chinese, that 6,390 number you just mentioned. So they all of these numbers kind of interplay with each other. It impacts the visa lines, and there's so many unknowns that we are kind of just having to guesstimate and conceptualize what could happen. Whether what actually happens remains to be seen. But the real big question I think that everybody has is, well, when is there going to be a final action date for the reserved EB5 categories? I get that question asked to me every day, about 10 times a day. And so I figured we should talk about it here. And there's no one better to talk about it than Charlie. And so maybe just give us a rundown of where we thought we were with final action dates 9 months ago and where we are today based on the data that we have.
Right. First, I'd like to mention, in terms of the rest of world applicants opting in from reserved, opting into unreserved, based on the fact that the reserved categories are current now, in my opinion, there's absolutely no need for any reserved rest of world applicants to be opting into unreserved. They would only need to do so when the rest of world final action date were to be applied in their applicable reserved categories. So again, in my opinion now, there's no need for reserved to opt out. In terms of dates, a year ago, it would have, my estimate was, I knew that there were the rural category was reserved was getting expedited processing. So I knew that there would be a lot of approvals there, but I also expected the Immigration Service to devote a reasonable amount of resources to the processing of high unemployment cases. So at the time, a year from ago, I kind of expected that based on the amount of petitions, that high unemployment area might have a final action date before rural. At this point, the data which has been released by USCIS indicates that actually, based on the amount of approvals, a rural final action date would be imposed long before any high unemployment final action date, which, again, a year ago, I would not have expected that. But again,
let me just pause there, Charlie, for a second. And the reason why we thought that is because there's twice as many visa numbers for rural as there is for high unemployment. So the assumption is
Yeah.
if the demand's the same, you're going to have a shorter backlog for rural than for high unemployment. What we're seeing, however, is that USCIS is adjudicating 3 times as many rural applications as high unemployment, and that has changed our analysis.
yeah. And also at the time, the amount of applications for high unemployment petitions was much higher than it was for the rural categories. So again, it's right now, unfortunately, we don't have any real good historical data to make the estimates on. But both the State Department and USCIS is going to have to increase the amount of approvals and their processing very significantly before any final action date would be required. Because a final action date should only be applied when the amount of numbers used through that point when the decision is being made is that plus what the expected demand is in the current and upcoming month will exceed the amount of numbers available. So I don't think that they'll be legally required to impose a date in the foreseeable future. Based on the best information we have at this time, I would not expect a rural final action date to be applied before April of 2026, if then. And I would not expect a high unemployment final action date to be applied until at least the summer, if then. And again, this is based strictly on the data which has been released up to this point. Subsequent data could change my analysis of that entirely. But again, the government has not been real forthcoming in providing data on a regular basis for which is needed.
Yeah, and I guess my comment would be is we don't have the data that USCIS and the Department of State has. And so it's possible that we see something sooner than Charlie's estimates because they have the data that we don't.
Yeah.
And there's a lot of, I've seen a number of I-526 approvals, whether it's through a mandamus lawsuit or organically over the past few months, that just hasn't been reflected in the data yet. And so if they really do start dramatically increasing these 526 approvals and start using numbers and issuing these adjustment of status approvals and the conditional green cards, well, then we may have to change our estimates again. It really is one of these things where we are constantly revising because new data comes to us.
Yeah. The other important thing is historically, the State Department has processed the highest amount of EB-5 visas have been processed overseas. With this new concurrent, under the Reform and Integrity Act and with concurrent filing, I think there's going to be a dramatic shift in this. And again, State Department has published number use data through May on the individual visa categories, which unfortunately shows very low amounts being processed, but we have no idea how many adjustment of statuses have occurred. And I think that future processing in the reserve categories may be 60-40, 60% overseas, 40% in the states. But we'll just have to see. But again, I think that with so many people being able to file concurrently, we may see a dramatic uptick in the amount of numbers being used by USCIS. And unfortunately, we do not have monthly data to rely on in that regard.
Yeah,
Yeah,
perfectly
so it's
said.
one of those
I
things that
think
we're
that,
just going to have to.
yeah. I think the concurrent filing aspect of it really does keep a little, that groundswell that comes from that is tough to determine within the data, and something that we're going to have to keep watching and waiting on. I mean, your insights in terms of of when we could actually be seeing a day of file action is just vitally important. I think to everyone, again, as they try to make a good, strong decision, because as we've discussed multiple times, the ability to concurrently file is one that is in place because your visa category is current. And so while there is that demand has been there, that amount of investment has happened to the point that there is going to be a day of file action at certain points, and that is something that people need to take into consideration as they make their decision. But being able to concurrently file and getting those benefits that go with their I-485 is a huge benefit for people, and one that we've seen many people take advantage of.
Yeah, and important on concurrently filing to remember that if you've done so, even if a final action date is imposed at some future point, the people that have filed in the U.S. are able to stay in the U.S. until their case becomes eligible for final action, which is, again, a tremendous benefit provided to people that can file concurrently.
Absolutely.
The other point that Charlie mentioned to me recently, which I had never really considered, which I think really impacts how like you can actually make an estimate, is that USCIS is not processing these on first in, first out. And because of that, let's say you are filing with a project that does not have a 956F approval. That case is probably going to get adjudicated after a case that is filed um, that has a 956F approval, even if it is filed subsequently. And so, because of that, it's not like first in, first out on how they're looking at these. That impacts as well um, how we can make estimates. Charlie, you can probably um, state that a little bit more eloquently than I can, but that's a big difference for you.
Yeah, I think you're absolutely correct. It makes providing estimates of final action dates and how they may move extremely difficult because, unlike the employment first, second, and third, where you have a lot of people already in line, that with approved petitions, you can make reasonable estimates of how fast things are going to move. But as you say, if they're processing all over the map in terms of when petitions have been filed, it makes it extremely difficult. And that may play into an advantage when final action dates are eventually imposed, because if they do not see that they have a large amount of approved petitions, they may have a final action date that is much later and more closer to current than would otherwise be possible if they had been processing things in a first in, first out process.
So I would say that this is, again, just like the gold card, something that we're constantly keeping our eye out on developments for. And it's why you need to work with an immigration attorney who really understands this stuff. You need to work with a regional center who's able to move and act as these changes occur to help best protect their investors. And so we look forward to continuing this conversation. We do a Chatting with Charlie every month. It's on YouTube. You guys should definitely listen in. My email is on here, jbarnett@wolfstorff.com. We are one of the top EB5 firms out there, top U.S. immigration law firms out there. And Pete, thank you again for having us on, and we look forward to working with Can-Am more.
Always a pleasure. Thank you guys so much. I think this is super informative. again, there's so many variables that people need to consider, and I don't envy people coming in. I think it's a conversation we have all the time when we talk to people. This is one of the biggest investments that you're ever going to make, certainly one of the most personal. And so, with the amount of factors, and especially this flood of new information that's come in the last week, making a good, informed, and pragmatic decision just becomes that much more difficult. But I think that this was great information. You guys are experts in this, and we really appreciate your time and your explanations of everything. I think we've given a lot of helpful information to people. Obviously, if anyone has any questions for me, please feel free to reach out to myself, to reach out to Can-Am. Joey, Charlie, thank you as always. Anything else that we've missed? Anything else you want to drop in?
No, just looking forward to the next one and hope you have a great afternoon. Thank you.
Yeah.
Likewise, you too. Thank you guys so much and have a great rest of your
All right.
days. And thank you to everyone for joining us.
Take care.